Hello and welcome back to James Kelly Speaks. I'm James Kelly, and I'm going to discuss something I've been asked for by a lot of people for a long time. It is a discussion of the glucocorticoid model of parental alienation, the glucocorticoid neurotoxicity model of parental alienation. I'm going to do this in multiple parts so that we don't go over too much of the time frame. I'm trying to keep this down to videos that are somewhere along the lines of 10 minutes, 20 minutes, 10 minutes to 15 minutes. So there's going to be a part where I'm going to stop and I'll continue it in multiple parts. I want to give it the thoroughness that I really believe it deserves. So, the glucocorticoid neurotoxicity model of parental alienation. There are 4 key improvements over any previous models. 1, the accounting for the prevalence of occurrence allows it to be seen as a naturally occurring defense mechanism rather than an aberrant psychopathology. And this is key. All previous models neglect this. Accounting for the dynamic of the third parent in the form of parens patriae, well, every model neglects that. The dissection of the betrayal bond from a psychoneuroendocrinological perspective that explains both the counterintuitive nature of the phenomenon and the adverse health experiences that result from this adverse childhood experience, consistent with the adverse childhood experience study. All the models miss this one. In fact, the adverse childhood experience study misses this as well. It's disturbing, but it requires such a multidisciplinary approach in order to be able to catch some of this that I can understand how they're missed. 4, and this is key, the path to identifying the empirical evidence of the physical harm to children as an effective legislation. This is the first time this has ever been done. Was my paper where I identified Title 4D of the Social Security Act as a vector of an epidemiological vector of glucocorticoid neurotoxicity, and this is what results from that. So, moving on, parens patriae was originally the legal philosophy justifying the state intervention in the lives of children when the parents are unable or unwilling to protect them, and that was from Ex parte Krauss in 1838. It is not used that way today, unfortunately. So, we have a family system, a family system set up here where it's an unhappy family just before separation. You have the dysfunction that I've described previously in narcissistic defense mechanisms, and the empathy impaired parent is empathy impaired as a function of the hypercortisolemic wound that I described in the video before that. This is a series of videos, so it's important to understand them in order. Otherwise, you're coming to it kind of in the middle of the game. So, you have parens patriae that still sits up above and out of the way, not involved because there hasn't been any kind of separation. And then there is. And then parens patriae inserts, the courts insert themselves into the middle of this. The child still has a positive relationship with both parents, and that's key to understand. But the two parents, well, they've lawyered up, they've got the courts in the way, and parens patriae just kind of gets right involved as a function of all the court system and all the services. Now, you have the dynamic here that gets complicated really quickly. So, the empathy impaired parent is the active participant here. The least empathy impaired parent doesn't have to do anything other than breathe. So you have the loving parent that is feeling less than, feeling like they need to overcompensate, feeling like in order for them to continue to have the relationship with the child and protect the child, which could be a function of reenactment trauma. It could be It could be them realizing that they are not experiencing emotions like they would like to, like they think they ought to be able to. And so in overcompensating and to have the child like them instead of being left out, they either falsely or exaggerate the other parent, the least empathy impaired parent, as a threat. And so from the child's perspective, and it's always important to look at this from the child's perspective, you have the cognitive dissonance of a loving parent that has become a captor and a loving parent that has become a threat. Well, that's cognitive dissonance, two very uncomfortable things for the child. And that raises their stress in not just one place, but two. So when you have that elevation in stress, that's not good. But at the same time, what happens here, the parent doesn't have to badmouth the other parent, although it's quite common. What the parent has to do is activate the child's attachment system. So by identifying the other parent as the threat and the child as the victim, it activates the child's attachment system for that parent. And it kind of degrades this relationship. So that's important, but that's not the only stress the child sees. I'm going to depart for a second here, and I'm going to go and discuss some of the issues around parens patrae. In 2012, there was a study by Dr. Saunders and others for the United States Department of Justice that identified the false attribution error by judges in 70% of the high conflict cases to give or award custody to the most abusive parent. This is important because that's significantly greater than a coin toss. So this isn't by accident. This is by design. Okay? Now, the design is, when you read through the characteristics of Title IV of the United States Social Security Act, you start to understand exactly what that design is. And I would recommend anybody to read that. And I'll get into some of the other reading later. But this is foundational for the third parent that's supposed to be a neutral third party, now identifying this parent as the good parent and that parent as the bad parent. And it elevates, it how do I describe this? It results in a deprivation of the child's rights to freely associate with both parents equally, to freely and appropriately love and be loved by both parents. It puts the child in the position of being used by proxy for power, control, and financial gain. And it actually puts the child in a situation that I believe can be proven empirically, where physical harm to the child results from the legislation of Title IV within the Social Security Act. So let's go back and let's look at some of these things. 18 U.S.C. 242 is the criminal deprivation of rights under color of the law. And this is how it reads. You can see it yourself on that particular URL if you want to look. But the key things here, and I've highlighted them. Whoever under color of any law, statute, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges secured by or protected by the Constitution or laws of the United States shall be fined under this title or imprisoned not more than 1 year. Judges are an exception. They have judicial immunity. And this is certainly supported by the 1978 U.S. Supreme Court decision of Stump v. Sparkman. So let me continue. If bodily injury results from the acts committed in violation of this section, or if the acts include the use, attempted use, or threatened use of a dangerous weapon, shall be fined under this title or imprisoned not more than 10 years or both. And if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, shall be fined under this title or imprisoned for any term of years or for life or both, or may be sentenced to death. So, Troxel v. Granville. That's a key ruling from the Supreme Court, and while it goes through some of the key points here, one of them being the liberty interest at issue in that particular case is the interest of parents in the care, custody, and control of their children, the oldest fundamental liberty recognized by the U.S. Supreme Court. So, they go on in detail to explain due process clause, and I've put some of that up there. But this is foundational for the corollary that children also have constitutionally protected rights. So, I'm going to break off at this point, and we will continue on in going through the model and exploring in the next part a little bit more of the counterintuitive process of why a child bonds to the most abusive parent always and not the least abusive parent. So, please like this, please subscribe, please share it, please like my Facebook group page, the petition to scientifically study Title IV, and please share that as well. It is important that we look at this scientifically and from a different perspective to get things changed. So thank you again. I'll talk to you on the next video.